Hi, I hope you have a fantastic weekend. Today, another episode of Guest with Nazir. We have a special guest, Rifaqat Ali Hussain. Welcome, Rifaqat.
Thank you for inviting me. Assalamu alaikum.
And could you please tell our viewers about your early days and your education?
Okay, about my early days. Well, I did the law degree in 2000. My dad pushed me back into law. He wanted one of his sons to graduate and have that gown and have the cap and have a photograph taken with him. He wanted to be really proud, but unfortunately he did pass away in the second year of my law degree. God bless his soul. And then I did, once I qualified, did my law degree, did my LPC. I went to Pakistan for about a year and stayed there, and then I came back. I applied for a job at Parker Road. It's called now Parker Road Hikmats. Continued to pester the managing partner who gave me a training contract, and I then qualified. I've been brought up in Sheffield majority of my life, and I've lived here, and I now have a practice here in Firth Park.
And how do you feel profession being changed in a few years' time?
The profession, as it's changed, I think it's got a lot harder. Back when I was doing the law degree in 2000, I think the profession was seen as a good profession to get into. You know, you could make a decent wage in the profession. You know, it was a respectful job. I think now it's still classed as a respectful job, but it's a lot harder to get those training contracts. I think a lot of the law students will agree that do the LLB, LPC, that you can't get a training contract very, very easily unless you really know or work hard towards one. And I think a lot of employers will now want you to work for them to prove yourself, and you'd have to be valued within that organisation before they give you a training contract. I do feel that.
So which area of law you have chosen as your special subject?
It's funny because I didn't really choose it. Because when I started working for Parker Roads, I went into the immigration department, and I kind of just got stuck there. I just developed as a caseworker, and then got the training contract. I did a little bit of conveyancing as part of my training contract. I didn't really like it, so you know, it was just something that I wanted to do, was litigate. I wanted to do the court work. Yeah, so I just stayed in the immigration asylum field and then moved on.
Recently, the present government has introduced on 6th of April new changes, especially about the health surcharge on the new application. What is this new change and how it affects the applicants?
The NHS charge, the drastic NHS charge. The applicants now, since 6th of April, have to pay a fee. The money is going towards NHS. We don't know where it's going to actually go, but they're raising £200 per year of everybody being granted leave to remain. So, for example, a spouse who applies from abroad to join a spouse in the UK would have to pay £200 per year. So if they're given a 3-year visa, they'd have to pay £600 before they're allowed to come. And that's on top of the embassy fees, which have also gone up to £956. So effectively, you know, it's like double, they're paying double. In addition to that, once the spouse comes to the UK, and they have to apply for that extension after 2.5 years, they have to pay again. They have to pay the NHS charge again at that time when they submit the extension application, which is roughly about £500. So the government's going to make a lot of money. The estimated is about £200 million from this NHS charge in this coming year, which I think is really unfair. If you have, I've got a client at the moment who is applying for an extension of their leave. They have discretionary leave to remain at the moment. They're applying for an extension, and they simply can't afford the NHS charge. He's got the money for the application fee, but he does not have the money for the NHS, and then therefore he's going to become an overstayer. So we're going to submit it, so it's in time, and then hopefully later on, when he's got the money together for the NHS, we're going to put that in.
But the government's argument is that they have to find money somewhere. The people who are coming, they have to contribute towards the cost of the NHS services.
Yes, true. But why the £200? Why 200? Why not £50 or £100 or £200 and that's it? Why £600, which is nearly another embassy fee for some people? And it's really unfair where the main applicant has to pay and then the dependents have also have to pay. What about those that are fit, never going to use the NHS? Do they then get a refund? No, they'll not get a refund. So they do have to contribute, but I think the £200 itself is really unfair.
And in terms of appeal rights, recently a lot of changes has been introduced by the government, and how you see that the removal of right of appeal in a lot of applications and process of this immigration system?
Again, I think it's unfair where the government has introduced a review. It's basically the same people who are reviewing the application, so they're making money again. You have to pay for a review. The review then goes back to the entry-clearance officer who will review the case. But how do you know? There's no third person, there's no in-between, there's no judge who's going to be looking at this case with like different sets of eyes. It's going to be the same people who are going to be looking at the review and probably dismissing it, and then the only challenge would be to the High Court. So it's really pushing away the appeals from the tribunal to the High Court or the upper tier.
So what are the proposed costs for this review? So how much they have to pay if they want to review?
On the top of my head, I think it's £80 that they'd have to pay for a review. My colleagues recently done one, I can't remember off the top of my head, but I think it's about £80 that they have to pay for the review. But if, again, like I said, if it's refused and they maintain their decision, one does have a right to go to the High Court to challenge that the decision is irrational or so forth. But that's, again, pushing the cases from one area of the judiciary system to another area of the judiciary system. So it clogs up another artery at the courts.
And what's about this NHS surcharge? Will it affect the student visas also?
It's anybody with limited leave to remain who would have to apply, apart from visitors. Visitors have 6 months, so they're exempt. They don't have to pay the NHS charge. But anybody else who is applying for limited leave to enter the UK, students, work permit, tier applications, spouse applications, they all have to pay the NHS charge. Yes.
And in terms of the new applications, the government is also changing the fees. How you see as an immigration practitioner the all the time increase in the fees, how it's affecting?
How it's affecting people in terms of do they come forward and put the application in? I think they do come. When the visa is about to run out, they still have to come and make that application. What I fear, because the fees have gone up on the 6th of April, what I fear is a lot of people who are unable to afford it. I'll give you an example. Somebody who's coming up to applying for indefinite leave to remain, the fees have gone up to £1,500. That's for the lead applicant and also the dependent. So if you have a child, that's £3,000. If you have two children, that's £4,500. Somebody who's applying for indefinite leave to remain may not have that £4,500 sat away, in the bank just to cover the fees. What does that applicant therefore do? Does he overstay or submit an FLRO application and apply for an extension, but he still has to pay the fee and he has to pay the NHS charge? So it's more or less similar in terms of money that the government is going to receive, which I think is unfair. So I think it may drive some people not underground but illegal until they can stump up the fee, and then they can then pay and cover the fees.
Sometimes immigration lawyers talk about the out of immigration rules application. What are those applications and how it works?
The out of rule applications. Years ago, you could submit an application and you could say to the government, to the Home Office, you could say, look, this person does not fall within the rules, but he falls under case law. You look at your own policies, he falls within your policy, and therefore please allow some kind of discretion in this case and grant some kind of discretionary leave. Nowadays, you have to look at the immigration law, the new Immigration Act. For example, if you have somebody who is applying under Article 8, for example, the Article 8 is kind of been codified in the new Immigration Act 2014. You have to look at Section 117, and it sets out the criteria that a person has to meet in order to meet Article 8. I think with legal aid going out of scope, less and less decisions are being challenged to the higher courts, and therefore it's going to be difficult for people to get a decision in their favour. But there are people who still apply. If you have a British child in the UK, for example, you can submit an application that you want to remain here because you've got a British child in the UK, and the Home Office are granting those people leave to remain, but with no recourse to public funds, and that person would have to reach the 10 years in the UK before that person can apply for the indefinite leave to remain.
And as an immigration lawyer, how you see what are the common mistakes people are making in their application, and applicants are facing refusal? So what are the main those mistakes which commonly people are making, and cases are going to from refusal and then to appeals and then for reviews?
Yeah, I think the main mistake people make is that they don't go and get legal advice. I think it's really important that they should get the legal advice. I mean, the way we do it at our firm would be that the person would come in, we would give them the advice, we would give them written advice, and we'd set out exactly what documents they will require in order to meet the immigration rules. What people are failing to do at the moment, I believe, for example, in spouse applications, is it's the Appendix FM. It's the maintenance part of the rules. Can the sponsor in the UK maintain their spouse coming over on the finances? So the threshold is still £18,600. How do you meet that? There's specified documents that person would require in order to meet the rule. Now, some people are thinking back years ago, we'll put this in, that in, and it'll be okay, and it's like the old school. But it doesn't work that way anymore. They're kind of like codified now, so what you need is there, it's in the rules. It's just some people have difficulty getting their heads around it. So, for example, I had one, again recently, who came to me after he'd lodged the application, paid all the money, got refused, and he's asked me to do the appeal. Now, the entry clearance officer has refused it on one thing alone, and he said that your payments into your bank do not match the payments on your pay slips. Now, the pay slips stated that he was getting paid in backs. It's a bank transfer from the employer's account to your account. But he was getting paid cash, so he was going physically to the bank and putting the money into the bank. And they refused it on that point. It says, if it says backs on your pay slips, why are you putting money in cash into your bank account? So there was an error on the pay slip. So he'd not checked it, and I think it was just a standard pay slip that the employer had printed. Probably one of those that you get off the internet, and he's given it to his employee. The employee's not checked, and he's submitted it with the application. So he's lost the embassy fee, and now he has to pay for an appeal. So he has to pay another £140 to go to the tribunal, and hopefully it'll get reviewed by the interclearance manager. But if he doesn't, then he has to pay and go to the court. And
what are the implications for the applicants, especially on all immigration application, in the light of Human Rights Act?
In terms of the Human Rights Act, Human Rights Act, for example, again, Article 8, it is evolving all the time. There's new cases coming out every month, more or less. The old historical Article 8 cases still apply. There was a case of Rasgar, Beko Berts. There's many cases from the House of Lords and Supreme Court. They're still higher authority cases, but those cases came out before the new immigration rules. So one can still argue that those cases still apply, and we certainly still use those cases as part of our submissions. And some judges do like the old case law, and some judges don't go with it, and they just look at the rules and the new Immigration Act and try and fit a person's situation within that case, within that statute, or otherwise it's dismissal. So it is problematic, but with legal aid changes and immigration, Article 8 no longer in scope, people sometimes go to the court on their own because they simply can't afford legal representations. Hopefully, if another government wins the elections, there may be changes. Maybe they won't. Who knows? But certainly, I think solicitors are there to help, and people should seek legal advice if they're making certainly complicated applications.
Now we come to the lighter subject. Your favorite place?
My favorite place. I'd say the studio. Favorite place? I don't know really. I mean, in terms of food, there's we go to Mir Bridera quite a lot, which is in Attercliffe. We go to Akbar's in Rotherham. In terms of in the UK, I would say Sheffield is my favourite place because I've lived here. So,
thank you. And in terms of sport, your favourite sport and player?
I don't really watch sport. A lot of my time is taken up with work, to be honest with you, because I run my own business now with my business partner. Predominantly the weekends are taken up with the family, with work, with mum, brothers. I've never really been interested in sport, and I don't understand why people would watch football, for example, or cricket. It's a little bit dry. I mean, I don't mind playing it, but I've never had the urge of sitting there and watching sports. So really, I don't really have a favorite player.
I see. It's quite interesting. And in terms of the proud moment or the best moment of your life?
Best moment. I think the proudest moment would be qualifying, getting the law degree. And I would encourage all the kids out there to get out there, get a good education. And when you stood there and you're getting your degree and you've got your cap and gown on, it is proud. It's proud. You're proud for yourself, and you're proud because your family's proud of you, your friends are proud of you, what you've accomplished. And I think if you go into law, you qualify as a solicitor, and you get your practicing certificate. I've still got my first practicing certificate, and that's a proud moment as well. So I think in life, if you accomplish anything in life, I think you should be proud of yourself, even if it's a little thing or a big thing. You should be proud of yourself.
And in terms of youngsters, as you mentioned about the young people, that what are your guidelines for them if they want to pursue the legal career?
I would say try and get some work experience in a solicitor's office. We've had a number of apprentices who've come through the doors. We've taken on children from the local schools. We've given them work experience. We've had somebody who came from the local college and worked for us during the summer, and who has also gone on to do law in Reading. And she does come back now and again and seeks advice, and we may give her a job at the end of it. And I would say get your foot in the door, establish yourself. The person that we've got at the moment, Tatenda, he pestered us and he wanted a job, and eventually we caved, and we thought he was really enthusiastic. He's done his law degree. He's working as an assistant for us at the moment. And I would encourage anybody like that, to pursue who you want to work for. And
what is your short message for our viewers?
In terms of law, I would say seek the advice from a lawyer before you put an application in, even if it's just something that you want a solicitor just to look through the documents, for example. Seek advice. If you want that person to make the full application for you, they can do that. They're better placed to do that than yourself. It's a lot of money to lose in terms of fees. But again, if you do put that application in yourself and it gets refused, come to me, come to any lawyer who does immigration and specialises in it, and hopefully your appeal will be successful.
On this note, that always seek independent legal advice. From me, goodbye I hope you have enjoyed this show. Ali, thank you very much for joining me.
Thank you very much for inviting me. Thank you.